Hi again, and welcome to the last topic we're going to talk about, the federal and state courts. Today we're going to talk about the federal court system, and particularly we're going to start with some background on the three layers of the court system. There are three levels of courts in American politics. The first is the Supreme Court. This is the highest level. It's followed below by the appeals court, and the lowest courts at the federal level are the district courts. When cases work their way through the court system, they start at the bottom. So they'll start in the district court, and then they'll go to appeals court, and then they'll finally end up at the Supreme Court. It works its way for the overwhelming number of cases. There are some very, very limited exceptions where a case can go straight to the Supreme Court. That's very rare. Most of the cases, probably 95 to 98% of them, they start at the bottom and work their way up. I have a graphic to show you how things work at the federal and the court. You don't need to memorize the graphic or anything, just know the three levels and that the Supreme Court is on top. But you can see this is typically how it works. The U.S. district courts get a case, somebody loses a case. If they have reason to appeal, they'll appeal to the U.S. Court of Appeals, and then finally they'll end up in the Supreme Court. And state courts typically work very similarly. There's this one section of cases that can go straight to the U.S. Court of Appeals, and there are also one or two situations where somebody can appeal straight to the Supreme Court. In other words, like a state Supreme Court makes a decision, somebody wants to appeal that will go straight to the Supreme Court. But generally speaking, this is the process. So let's walk through from the bottom to the top the different courts, what jurisdictions they have, what authority they have, in other words, and the background on this, and then we'll stop at the Supreme Court and talk about Supreme Court decision-making specifically. So at the lowest level are district courts. There are 94 courts and 632 justices at the moment. You don't need to know these numbers. I give them to you just as background and a sense of how many of these there are. Every state has at least one district court, and obviously because there are 94 courts in 50 states, some states have multiple. The district courts operate as trial courts. That means they hold a trial like you would see on Law and Order. There's a judge and so forth. And there are two types of cases that a district court will hear. The first is a criminal. This involves the government trying to prosecute an individual, basically something that the government can put you in jail for. That's a criminal case. And the other type is civil cases. Civil cases are when individuals sue each other or individuals sue a government agency, or somehow it's not a criminal prosecution. So this is all we're going to talk about with the district courts. This is, again, just some basic background on them. The middle level are the appeals courts. Now, technically, these are called the U.S. Circuit Courts of Appeal, but as you'll see when we talk about the Wyoming legislature, that circuit court language can get really, really confusing. And so we're just going to call them the appeals court. I think that's the easiest way to remember. There are 13 courts around the country. There are 179 judges, and these appeals court usually sit in 3-judge panels. What that means is that instead of having one judge and a jury and lawyers presenting the evidence to that judge or that jury, the appeals court will have 3 judges. And the lawyers will argue for why the appeals court should overturn the lower decision or not. Again, the term appeals simply means that they overturn or uphold the lower court ruling. The district court will make a ruling on a case, and one side or the other will believe that that case was wrongly decided, and they will appeal it to this court. They'll ask the appeals court to overturn or to uphold the lower court ruling. You can see a map down here of all of the courts of appeals. You've got, for instance, the Ninth Circuit Court here that represents the West Coast and Alaska, Hawaii, Guam, and so forth. And you've got the 10th Circuit Court of Appeals that includes our own state, Wyoming, Colorado, and some others. So that's all we're going to talk about with the appeals court. The main thing to know is simply that their primary job is to uphold or overturn lower court rulings, and that they typically sit in 3-judge panels. And finally, we get to the Supreme Court. There's only one Supreme Court. That's why it's supreme. And there are 9 judges that sit on it. The Supreme Court is often called the Court of Final Appeal. What that means is that when a case is appealed to the Supreme Court will rule on it, and there are no appeals higher than that. There is no other entity or other court that can overturn a Supreme Court decision. Now, the Supreme Court actually has two types of jurisdiction. You'll want to know these. The jurisdiction simply means what kind of cases they can hear. And the first, and also the more rare one, is what we call original jurisdiction. When the court acts on its original jurisdiction, it typically acts as a trial court when a case is involved. Again, trial court just means they hold a trial exactly like you would see on television shows, Law and Order, and so forth. The court only acts as a trial court when you're talking about cases involving ambassadors or foreign countries, or when a state is being sued. If a corporation or individual sues a state itself, the Supreme Court will hear it and the Supreme Court will hold that trial, not the district court. So that's the first one. Second is they operate under appellate jurisdiction. This just means they're an appeals court, right? Appellate means appeal, so this is where they hear appeals either from lower federal courts, particularly appeals court, or a state Supreme Court, as we talked about. The important thing here is to understand the difference between original jurisdiction and appellate jurisdiction, and also to understand that it's really very rare for them to operate on original jurisdiction. The Supreme Court very rarely acts as a trial court. They mostly act as an appellate court. All of the Supreme Court cases we've talked about throughout this entire semester, the Supreme Court has acted on its appellate jurisdiction and acted as an appeals court, not as a trial court. So those are the three levels of the court system. Let's talk about Supreme Court decision making. There is a three-step process that Supreme Court goes through when deciding a case. The first is they have to decide to hear a case, as we'll talk about in a second. That is called a writ of cert. But the Supreme Court first has to agree to hear a case from the appeals court below it, and they do not hear every case. There are many cases that they, in fact, refuse to hear. The second process is that they have to make a decision on the case. So they've chosen to hear the case, they have to rule on the case, and then the third, they have to announce their decision to the public. And this process is actually a little different than how you might think they would do it. Now, let's walk through each one of these steps. And let's start with the realization that the federal courts have a huge caseload. In 2004, for instance, the district courts handled 370,000 criminal and civil cases. That's a lot. The appeals court handled 67,000 cases, and remember, there's less than 20 of these appeals courts around the country. So that's a huge caseload for the appeals courts. And finally, the Supreme Court heard less than 100 of those cases. Out of the 370 criminal and civil cases that the district courts handled, the Supreme Court only heard 100 of them. What that means, and the most important part, is that the Supreme Court is extremely selective about hearing cases. Not only do they not hear all of the cases that are appealed to them, they actually only hear a small fraction of the number of cases. How does the Supreme Court choose to hear these cases? What decision-making process goes on? We're going to talk about that. The first is understanding the writ of cert. Not the powerful mint certs, but cert is simply short for certiorari. I'm not even sure I'm pronouncing that word correctly. That is Latin for, quote, to be informed. It's simply a request by an individual to hear a case. There's a formal process that occurs after an individual has lost a case at the appeals court or state Supreme Court. They will file a writ of cert to the Supreme Court, and they will formally request that the Supreme Court hears that case. What determines whether the Supreme Court accepts or rejects the cert? In other words, what determines whether the Supreme Court will choose to hear or to not hear a case? Well, there is one rule. There is only one rule that governs whether the Supreme Court accepts or rejects cert. It is called the Rule of Four. This is simple, but it is very important. Basically, the Rule of Four is this: 4 justices must agree to hear the case. If 4 justices do not agree to hear the case, they will not hear the case. If 4 or more justices do agree to hear the case, they will hear the case. It's that simple. You can think about it like the holy hand grenade of Antioch in the Monty Python movie. The counting of the number shall be 4, and 4 shall be the counting of the number. The counting of the number shall not be 3 unless immediately preceded but 2, 4. 5 is right out. Okay, that's the last bad impression I'm going to do all semester. So what influences this decision to accept or reject a case? There are 2 main ones. The first one is not really going to be on a quiz, but hopefully it's just obvious. It's strategy or strategery. See, I lied. That really is the last bad impression that I'm going to do. Basically, so members of the Supreme Court are not going to agree to hear a case if they know that they're going to lose. When would this be the case? On a controversial issue, if, let's say that you have 3 liberal members of the Supreme Court, and they know that 5 or 6 of the Supreme Court justices are going to rule in a way they don't like, those 3 are not going to agree to hear the case. And so there is a certain strategy that goes on behind the scenes in terms of when a Supreme Court justice will agree or not agree to hear a case. And that's important, but the more important one is the importance of the case itself. How important is that case? There are 2 aspects or 2 ways that the Supreme Court looks for the importance of the case. The first, and probably the clearest one, is a split in the appeals court. The second one is cues from other actors or other entities in the process. First of all, what do we mean by a split in the appeals court? Remember that map of the appeals court that I showed. A split in the appeals court simply means that, say, the Ninth Circuit Court of Appeals, they ruled one way on an issue, and the Fourth Circuit Court of Appeals ruled an entirely different way. The clearest example of this were the early Second Amendment cases just a few years ago, where some appeals courts ruled that the Second Amendment is not an individual right, whereas other appeals courts ruled that it was an individual right. Now, hopefully you can see the problem with that, which is that in one part of the country, you had the Second Amendment meaning one thing, an individual right to bear arms, and in another part of the country, you had the Second Amendment meaning something completely different, a collective right to form a National Guard. That's a problem because the Second Amendment cannot mean 2 different things. And so a split in the appeals court simply signals the Supreme Court that there's differences in opinion among the lower courts about the meaning of some part of the Constitution, and that makes the case important for the Supreme Court to step in and resolve that disagreement, as they did with the Second Amendment, where the Supreme Court stepped in and ruled that the Second Amendment is indeed an individual right to bear arms. The other reason that this is a huge problem, a split in the appeals court, is that appeals court rulings only have effect in the states over which the appeals court has authority. So a ruling, for instance, by the 10th Court of Appeals would apply to Wyoming but not Montana. So a split, going back to the early Second Amendment cases, the split or disagreement over the Second Amendment by the appeals court meant that local governments in, say, Illinois, where one of the famous cases came through, those local governments could ban handguns. In another part of the country, in Texas, where another famous Second Amendment case was heard, local governments could not ban handguns. So the consequence of a split in the circuit court is completely different policies depending on what state you're in. And so again, hopefully you can see why the Supreme Court would look for a split in the appeals court as a signal that they need to take the case and need to weigh in on it. Let's turn to cues from others and what we mean by that. There are a lot of cases, 370,000 cases that make their way through the federal court system. And so the Supreme Court needs some quick way to highlight which ones are more important than others. A lot of actors will file what's called an amicus curiae brief. Amicus curiae is Latin for friend of the court. Law schools do love them some Latin, so a lot of the terms surrounding legal concepts are in Latin. But basically all this means is that interest groups and other parties that are very interested in the case will file an amicus brief with the Supreme Court. Now these cost a lot of money. On average it costs about $50,000 for an individual or a group to file an amicus brief. So several briefs filed from people on both sides of the case will increase the likelihood that the Supreme Court takes the case or grants cert. It signals a broad interest in the case from a lot of different actors, and it signals that there's disagreement about what the outcome should be. Again, going back to Second Amendment cases, just because we're talking about them, gun rights advocates on these appeals court cases, when they filed an amicus curiae brief, once the Supreme Court agreed to hear the case, you had gun rights groups filing a lot of amicus briefs. You had gun control proponents filing a lot of amicus briefs. The Supreme Court realized there's broad interest in this case. Plus there's a split in the circuit, and so they granted cert and agreed to hear the case. The second major actor that the Supreme Court looks to for cues is the Solicitor General. This is a picture of the Solicitor General. I'll confess I'm very bad with pronouncing names, and so I'm not even going to try to pronounce this gentleman's name, but he is a Solicitor General of the U.S. The Solicitor General's job is to argue cases on behalf of the President. So not just cases that the President's involved in, but cases that the federal government is interested in. The Solicitor General will become part of that case, and that's a signal to the Supreme Court that the government's very interested in the case. And so you can think about which cases that come before the Supreme Court are most likely to be heard and which ones are least likely to be heard. The ones that are most likely to be heard are ones in which, first, there's a split in the appeals court. Second, a lot of interest groups are filing amicus curiae briefs, especially for both sides of the issue. And third, the Solicitor General gets involved. When those three things happen, the Supreme Court almost always takes the cases. When those three things are absent, when there's not a split in the circuit courts, when the appeals courts are all in agreement, for instance, on an issue, let's say the interpretation of the Second Amendment, when very few people are filing amicus curiae briefs, or a lot of those amicus curiae briefs are filed only on one side of the issue, and when the solicitor sits it out, those are cases that the Supreme Court almost never takes. In cases where one or two of those things are present, the Supreme Court may or may not take it. So that's the background on the first step in the Supreme Court rulings. That helps us understand when the Supreme Court decides to hear a case versus not hearing a case. Let's turn to the second. The Supreme Court has to rule on a case, which means they have to decide for the lower court ruling or against it. And here again, there are two main considerations. The first consideration is what we call precedent or stare decisis. Not starry night, but it's more Latin because law schools love them some Latin. And it simply means let the decision stand. That's the meaning of stare decisis. The English version of this is simply the court follows past rulings. When the Supreme Court has ruled on an issue such as the Second Amendment, in this case the Supreme Court ruled that the Second Amendment is an individual right to bear arms, the Supreme Court later is very hesitant to overturn that. The reason mainly has to do with credibility of the court and also policy. It's very bad if the Supreme Court is switching back and forth one year to the other about the meaning of the Constitution. If one year the Supreme Court said the Second Amendment is an individual right to bear arms, and the next year they said no it's not, and then the next year after that they said yes it is, and so forth and so on, well then government's confused about what it can and can't do. And so the Supreme Court values the stability of it, and if the Supreme Court is flipping back and forth, it really makes you wonder, do they actually know what they're doing? Do they know the meaning of the Constitution or not? As we talked about with civil rights and civil liberties, the Supreme Court does change its views on these issues, but notice the timeline. Over 50 years went by before the Supreme Court overturned Plessy. Over a decade went by before it overturned its ruling on sodomy, and so forth and so on. So the Supreme Court doesn't do this every year. It can often take decades before the Supreme Court will very reluctantly go back and rule that a previous court opinion was erroneously decided. A few weeks ago we talked about Chief Justice Rehnquist and the Rehnquist Court. Rehnquist is a perfect example of the power of stare decisis. Rehnquist voted against the majority in the Miranda ruling. In other words, he said that police should not have to read people their Miranda rights when they're arrested. And yet, despite that, in a later case, he wrote the following. He said, "We conclude that Miranda announced a constitutional rule that Congress may not supersede legislatively. Following the rule of stare decisis, we decline to overrule Miranda ourselves." So even somebody who had strong opposition to a previous ruling then turned around once there was an opportunity to overrule the decision and did not. He let the previous decision stand, or stare decisis. So that's precedent or stare decisis. We already talked about it maintaining policy stability over the time and why the Supreme Court would want to maintain precedent. They don't want their rulings flipping back and forth because it undermines their credibility and throw government policymaking into disarray. The second main consideration is ideology. Yes, you heard that right. Supreme Court justices do often rule based on their personal opinions. This is sometimes called the attitudinal model. It simply means that justices rule on their attitudinal beliefs. It starts with the realization that justices do have opinions. They have opinions about matters of law, and they have opinions about matters of policy. And they are appointed by the president often for the opinions that they hold. Republican presidents often talk about how they're looking for a Supreme Court justice to rule a certain way on issues they care about, such as abortion, and Democrats often talk about how they look for Supreme Court justices who are going to rule their way on abortion. And so they do sometimes base the rulings on these opinions. It's an empirical fact that democratically appointed justices vote consistently liberal and Republican appointed justices vote consistently conservative. That's not true for all of them, but there are easily identified liberal and conservative branches on the Supreme Court that consistently rule the same way across cases and consistently rule with one another. Now, let me make a comment. This is not necessarily going to be on the quiz, but let me try to point out that the reality is a little more nuanced than this. I've presented these as two separate considerations. In reality, they're actually very interrelated. Ideology enters the decision-making of Supreme Court justices most strongly in cases where there is no precedent. So prior to the Heller decision, you don't need to know the Heller decision, it was a famous Second Amendment case. Prior to the Heller decision, the Supreme Court had never ruled on the meaning of the Second Amendment, so there was no precedent for them to follow. In that case, the Supreme Court's personal ideologies become very good predictors of how they're going to rule on the case. When there is strong precedent, however, ideology becomes a smaller factor, and so the effect of ideology depends really on how much precedent there is from past cases on that issue. Now let's turn to the third step in the process, announcing the decision. The Supreme Court justices, they cast their votes for or against the lower court ruling in private. And they operate on majority rule. 5 votes wins the majority. When 5 Supreme Court justices agree to uphold a lower court ruling, that lower court ruling is upheld. When 5 of them agree to overturn it, the lower court ruling is overturned. Once they've had the vote, once they've made all their arguments, and once they figured out or achieved 5 or more votes, one way or the other, they have to write an opinion. An opinion is simply a written explanation for why they ruled the way they did. And the person who writes the opinion is selected by the Chief Justice. He selects which justice will write the opinion, but only if the Chief Justice is in the majority. If the Chief Justice sides with the majority in this case, then he gets to select the justice. If the Chief Justice is in the minority, however, he does not choose who writes the majority opinion. There's also, as we talked about, it's majority rule, so 5 justices vote one way, they're the majority. But there are also minority opinions that are written as well. The minority will often draft 1 or more what they call dissenting opinions. Once they've written these opinions, once they've written out their explanations for why they believe they should uphold or overturn the lower court, they pass the drafts around, and then there's a process of revising and editing it. They have a long-going conversation with one another, and you can often see in the opinions themselves Supreme Court justice talking to the majority or the minority. So you can think about these opinions as a discussion with each other that is made public. It's not public when it occurs, but it becomes public much later. And then finally, the opinion is announced to the public. This typically happens in the summer between the months of May and July. And the Supreme Court does not release all of these at the same time. They work on them throughout the spring, and when the Chief Justice wants the decision to be made public, either because it's finally finished or the Chief Justice wants to time the release of the opinion to get more or less media coverage, by the way, that is also a strategic and political process, then the written opinions are typically uploaded to the Supreme Court website, the media is informed, and the opinion is announced to the public. Let's wrap up with a discussion about what happens after the decision has been made. Once the media has reported on the decision and it's been made public. Compliance with Supreme Court rulings is based largely on their reputation. Other branches of government, as we talked about earlier, can ignore the Supreme Court. We talked about this with Brown versus Board of Education, when the southern states and other states simply refused to comply with the ruling in Brown versus Board of Education and refused to end segregation. So once a court announces its opinion, that is not the end of it. As we talked about with civil rights, remember, Supreme Court victories are often the start of a political fight at that point, not the end of a national debate. So that's the federal court system. The next lecture is going to be a very short lecture about the Wyoming judicial branch, the levels of the Wyoming judiciary. I hope you enjoyed it, and talk to you next time.